Judge, welcome back. Congratulations on your last day of interviewing in your life. I'd like to talk about precedent. You've been a law professor. How long have you been a professor?
I started in 2007 was the first year. I taught 12 separate calendar years.
Okay. Let's pretend you're a sixth grade civics teacher for our 20 minutes together instead of a law professor. Okay. I think precedent's critically important, but I don't think the American people, it's not something we debate in front of them much, so it's something that maybe we could benefit from having more shared understanding about. Has the Supreme Court ever made a mistake?
The Supreme Court has made some major mistakes at times. Dred Scott, Plessy versus Ferguson, good examples.
How do you know when you have a mistake?
Sometimes you know right away, and I think in those cases, with the dissents written in those cases, those dissenters knew right away, and I think there were mistakes right away. Plessy versus Ferguson was wrong the day it was decided.
It's 1896, and we knew it was wrong when it happened. What was the ruling count? Do we remember the vote?
There was only one dissenter, Justice Harlan. The first Justice Harlan was the only dissenter in that case.
Okay. It's so close to McCain's event that I know we shouldn't be joking right now, but I just want to talk about lunch. Republican senators have lunch together 3 times a week, and whenever we do, if somebody's phone goes off, it was always John McCain's. When he'd get bored at lunch, he'd be watching CNN, and he wouldn't know that it came on at full volume 10, so it just felt like a ghost of lunches past. You wrote a really important article in Catholic Law Review last year, the 10 principles of good umpiring, and it wasn't about you as basketball coach, it was about the job of a judge. I'm going to speed through them, so I'm oversimplifying, but I think your top 10 list was, if you're a judge or if you're an umpire, you can't be a partisan, you've got no rooting interest, you've got no fan favorites. Number 2, the rules have to exist before the game. Number 3, you have to apply the rules consistently. 4, you can't remake the rules based on your preferences if your view of the game changes. Des Bryant a couple years ago, that catch at the goal line. It may be the case that the NFL decides in the course of a year that the targeting penalty doesn't work. A judge doesn't get to remake that rule on the fly. Number 5, you got to have backbone or courage. Number 6, you have to be able to tune out the crowd. Number 7, you have to have an open mind. You think you know what case is coming before you, and people may present arguments that are different than you thought. Number 8, you need the right demeanor and temperament. Number 9, you have to work collegially with your colleagues. And number 10, you have to be good at explaining. Rule number 2, the rules have to exist before the game. You then go from having a kind of paragraph by paragraph structure, you pause and have a long 2B, and you explain a little bit about precedent. Can you give us a 60 or 90 second view about how precedent relates to having rules of the game before the game?
Yes. Precedent is important for stability and predictability, and so to know what the rules are ahead of time is important for good judging and for good umpiring, and to do it consistently with how it's been done before, I think is part of the system of precedent. The point is when the rules are set ahead of time by the precedent or by the law, then you're not making up the rules as you go along in the heat of the moment, which will seem unfair. Which will seem like you're a partisan because you're going to seem like you're favoring one side or another because of allegiance to that team or favoritism to that team rather than applying the rules ahead of time, which is why in sports, as you know well, Senator, because I know of your devotion to sports, there are a lot of detailed rules that are set forth about how the game is played and how referees and umpires are supposed to call the game, and that's to ensure that there is predictability, there is stability, that the players can rely on that, and that it's overall fairness. Due process is not a word used often in the refereeing context, but it really is an element of due process. Notice about what the rules are ahead of time so that everyone has confidence in the fairness of the game, and that the umpiring, which is critical to the outcome of many games, is done in a fair and impartial way. So it facilitates impartiality, integrity of the game, fairness of the game, and it's true for games, sports, and it's true. I think the analogy is very strong, frankly, and this is why I wrote that article is because the Chief Justice, of course, had talked famously about the judge as umpire, and because I coach and play a lot of sports, and I really thought about the analogy, and I thought there are actually a lot of parallels between being a good judge and a good umpire. I'm a connoisseur of umpiring.
So I want to jump in here because I agree with you that the analogy is strong and tight, but I think it's imperfect, right?
Yes.
Because in a football, my dad was a football coach. In a football game, everything that's going to happen inside the four corners of that 120 yards with end zones is predictable in that Woody Hayes comes off the sideline in 1971 and punches a player in the face. That was new, and yet it was still non-participation. There's a rule you can only have 11 players. Coach can't play, another 12th player can't play. And so there was a rule that spoke to that. But in what you're doing, it's not as defined because the cases that may originate are not as perfectly cabinable, if that's a word, as in football, what might happen. So help me understand the distinction between judging as umpiring and the fact that the Supreme Court has made decisions in the past. It isn't the case that every decision a Supreme Court has ever made is right and is now a part of the permanent rule book. You sometimes have to throw them out. So sixth grade level, help us understand how from 1896 to 1954, you've repeatedly called Brown the greatest moment in Supreme Court history. I think it's one of the greatest moments in American history as well. In those 58 years, the court was wrong for that whole time, and yet the way we think about precedent, we might have our sixth graders thinking we should always take every received decision as right. So how do you reconcile the two?
Well, what the factors the Supreme Court looks at are whether the decision's not just wrong, but grievously wrong, whether it's inconsistent with the law that's grown up around it, what the real world consequences are, including workability, and then reliance. And one of the genius moves of Thurgood Marshall, among many genius moves he made as a lawyer, was to start litigating case by case. I mean, he knew Plessy was wrong the day it was decided, but he also knew as a matter of litigation strategy, the way to bring about this change was to try to create a body of law that undermined the foundations of Plessy. And he started litigating cases and showing case by case that separate was not really equal. And he did it in cases like Sweat versus Painter and many other cases. And he built up a record over time that by the time he went to the Supreme Court to argue Brown versus Board of Education, he had shown its inconsistency with the law that had built up around it. For those who weren't otherwise as quickly on board with the idea that Plessy was wrong the day it was decided. In other words, he was taking no chances.
I want to interrupt you because I want you to keep coming forward these 58 years, but just as a civics commercial, what you're describing right here in the new documentary, Marshall, every mom and dad and teacher ought to show it to their kids. I actually got to see it before it was out because Senator Harris gave me a copy and my kids and I watched it before it was public, but everybody should watch the Marshall documentary that's going through the history of what he was doing as a long-term litigation strategy. But continue, please.
Well, I think that by the time it got to Brown versus Board of Education, that the foundations for overturning Plessy had been strengthened by showing what the real-world consequences were and by building up a body of law that was inconsistent with the principle, the erroneous principle set forth in Plessy. And so he had a strategic vision of how to do this, which was brilliant, and he effectuated, along with a team of lawyers over time, litigating case after case after case and building up factual records that would show the harm, the badge, as the Supreme Court ultimately said, the badge of inferiority from separate educational facilities and separate facilities more generally. And that's how he was able to show that the precedent, even with principles of stare decisis in place, should be overturned.
But so if you're on the court during that period, that 58-year period, I want to get at some point to this distinction between precedent, super precedent, precedent on precedent, super duper precedent. But one of the reasons you think this is because of the Harlan dissent. So back up, and again, sixth grade level, what's the purpose of a dissent? Why do we write them?
We write dissents because we, in a multi-member court, disagree with the decision that is being made by the majority, and because we think that the issue is sufficiently important, if you're on the Supreme Court, that perhaps a future court will pay attention to your decision, or in a statutory case, sometimes maybe Congress will think that your interpretation of the statute was better, and maybe Congress will update the statute to reflect your view. But the purpose of dissents in constitutional cases, I think Justice Ginsburg has said this, Justice Scalia used to say this, dissents often speak to the next generation. And it's important, therefore, in constitutional cases of importance to have those dissents. And Harlan's dissent was a classic. It had some lines that are very memorable about the separation of the races in the Louisiana rail cars, and that law had just recently been enacted. So this was an example after the 14th Amendment, after the Civil War and the 14th Amendment. There was a period of positive movement, or at least some positive movement, not complete by any stretch. Strouder versus West Virginia reflects that in 1880, where the Supreme Court says, what is this but the law should be the same for the black and the white. That was a case where African Americans were being excluded from juries, all white juries, and the Supreme Court said no to that. But then any progress went backwards, and is reflected in the Plessy versus Ferguson decision, which upheld the separation of the races in that case. And so the Harlan dissent was very important for setting forth a clear principle rooted in the text of the Constitution and rooted in the principles of the 14th Amendment, and subsequently vindicated, at least on paper, of course, in Brown versus Board of Education.
Why do you write a concurring dissent?
So you can write a separate dissent or a concurring opinion in the majority opinion. Sometimes you'll write a concurring opinion to the majority opinion because you have a different rationale for reaching the same result. So you might have a...
So who's your audience?
Your audience, that's a good question. Sometimes it's also future courts, but oftentimes when you're at the Supreme Court level, I think, obviously don't know, but I think they're writing concurring opinions sometimes to influence or suggest things to lower courts about how this case, either another issue or a related issue or a tangential issue, should be resolved or thought about in the lower courts. Sometimes the concurring opinion is written to the future Supreme Court that might be 5 years down the road about an issue that's related to the issue being decided by the majority opinion. There are lots of different purposes that one might have for a concurring opinion when you're on the Supreme Court, at least as I've read them over the years.
So let me give you a hypothetical. You're on the court, and there's a 6-3 decision, and you're on the losing side. And so you write your dissent, and the next year there's a case that looks to you to be almost exactly the same, so you don't grant cert, you don't vote for it, but other people do. And so a case is coming back before you, and I know you're going to tell me that you need to be open-minded, and maybe the case is really different, and you were wrong when you didn't grant cert, but just bracket that problem for a minute. Let's pretend you're 6-3 case, you lost. Then there's a new case that comes before you. Are you supposed to have the view of the majority the next year, even though you disagreed last year, or do you write the same dissent again?
So as a matter of precedent, the ordinary course is that you follow the precedent of the Supreme Court, even if you were on the losing side, maybe especially if you were on the losing side. There are times where justices have persisted in their dissents repeatedly over the years, particularly in certain critical constitutional issues, or sometimes they have not persisted in the dissent but joined the majority but said, I still agree with myself back in the prior precedent where I had dissented originally. You see different approaches to this by different justices on different issues. I don't think it's a one-size-fits-all answer to your question, at least in terms of what the justices have done over time on that particular question. Most famously, Justices Marshall and Brennan dissented in every death penalty case because they did not accept the precedent of the Supreme Court that allowed the death penalty under the Eighth Amendment.
So how do you imagine you would act in that circumstance? If there's a difference, there's a diversity of views across justices in our history, but if you got the same case coming back the next year, Do you dissent again, or do you accept a majority opinion? Could you write the majority opinion?
Well, that's what I think a good judge does, which is once the decision's been made, you accept the precedent, subject to the rules of stare decisis, and yes, there are lots of historical examples where that has happened, and that's been done. Justice White had been a dissenter in Miranda versus Arizona famously, and then wrote many decisions applying Miranda subsequent to that, accepting the decision. Chief Justice Rehnquist, of course, ultimately wrote the decision where the question was whether to overrule Miranda, and wrote the decision reaffirming Miranda because he decided that at that point it had did not meet the conditions for overruling a precedent in that case. So I think ordinarily you get on board the precedent, but you might still write separately to say, I think this was a huge mistake and we should go back to a different approach. You see that sometimes. I think there are lots of permutations to the question you're asking, Senator, but in the ordinary course.
I want to ask him, but the chairman will only let me have 3.5 more minutes. He's miserly about this.
Yes.
What's the difference between an appellate court judge's job and a Supreme Court justice's job?
There are many. I think
But specifically with regard to questions where there's been a precedent.
so. At the D.C. Circuit level or the Court of Appeals level, we follow vertical stare decisis, absolutely. And that means that we are not permitted to deviate from a Supreme Court precedent. With respect to Supreme Court, or let's put it this way, when I'm on the D.C. Circuit and we're reconsidering in bank a prior precedent of our own, we can do that at times if the conditions for overruling a precedent are met. We can't do that with respect to Supreme Court precedent. We have to file that. And why is that? Because there's one Supreme Court in our hierarchical system, and lower courts have to follow that, or there'd be chaos in the federal system if lower courts weren't strictly bound to follow the precedents of the Supreme Court.
Is there a single Supreme Court justice today who agrees with every extant opinion of the court?
Oh, I think that's got to be zero.
Right.
Yeah.
So how does that get netted out in the next controversial case when you use these terms, precedent, super precedent, precedent on precedent? How does that get netted out?
Ordinarily, it gets netted out by the court following the precedent unless and until the conditions for overturning something are met. Brown versus Board being the most prominent example of when that happened. Erie Railroad case overruling Swift versus Tyson. There are examples throughout our history where that's happened, but it's rare. And ordinarily what happens is once a decision's been decided, that's what stare decisis means. You follow the decision that has been set forth by the Supreme Court, subject to the rules of stare decisis. And you see that time and again. That's part of stability. That's part of predictability. That's part of impartiality. That's part of public confidence in the rule of law, that it's not just going to move pillar to post, that the law is stable and foundational. Again, it's not, Brown versus Board shows it's not absolute, and that's a good thing, but it is critically important to the impartiality and stability and predictability of the law.
And the fact that Harlan should have been the guiding opinion for those 58 years isn't true just for the Supreme Court. It was also true for appellate courts. Could an appellate judge have gone with Harlan in 1940?
An appellate judge was bound by the precedent of the Supreme Court, and that would have been, sadly, Plessy versus Ferguson. That time.
So this is the core difference here for the Supreme Court is there's greater latitude to reconsider the previous errors of the court.
Of the Supreme Court, that's correct, Senator.
I'm at 30 seconds left, so I got to get my last one out to get in under the bell. I'll shift gears just a tiny little bit. What is the Declaration of Independence? In what way? The Constitution is fundamental law for us. What's the Declaration of Independence?
So the Declaration of Independence, first of all, is a legal document legally declaring independence, of course, from Great Britain, but it also sets forth a series of grievances against the monarchy, the system, many of which are reflected in the Constitution in terms of protections that are in the Constitution. If you trace to the Declaration of Independence, you see the grievances they had reflected in protections we have in the Constitution, starting with the separation of powers, but also including the individual protections, whether it is ex post facto laws or freedom of speech or quartering the Third Amendment, not much litigated, as we know, Senator, but all you can trace it. But this Declaration of Independence is a set of principles that I think guide our beliefs, life, liberty, and the pursuit of happiness. All men are created equal. All people are created equal in our society. And those principles have guided us, inspired us, been the source of our liberty, the source of much of what we've done as a country since the Declaration of Independence. But it's not law in the same way the Constitution is law that's applied in courts.